Well, good morning, everybody, or good afternoon, or good evening, depending on when you're listening to this session, which is the September 2021 Residential Property Practice Update, presented by me, David Keithley. There's the usual details. I'm sure many of you have seen that many times before, or have listened to me presenting on previous topics. So what I'm going to be presenting or talking to you about today are these 5 points here, which is a slightly sort of tongue-in-cheek question: has the Supreme Court killed conveyancing undertakings? And then again, slightly tongue-in-cheek. Does anybody know what we should or should not be doing in relation to the EWS1 certificates? That's a slightly rhetorical question, because the answer now is there is now some guidance, but I'll come on to that. And then what I think is a fairly practical issue in terms of restrictive covenants, and the sort of covenant that you and I come across very frequently, and the courts have given us some very useful guidance on enforceability of the sort of covenants, and you'll see what I'm talking about when we come to it. And then a case which has highlighted the real importance of making sure that people are fully advised on the difference between joint tenancy and tenancy in common, and then rounding off with a series of miscellaneous practice points.